10 common mistakes people make when appealing a Social Security decision. If you're holding a decision letter from Social Security that you believe is wrong, a few numbers on that page matter more than anything else in it. 60 is the general one. You usually have 60 days to request the next level of review, counted from the date you're treated as having received the notice. 10 is smaller and easier to miss. In certain cases, keeping your payments coming while the appeal is pending requires a written request within about 10 days, and filing a brand new application is a different procedure from appealing, not a substitute for it. Procedural errors like these can defeat, delay, or limit an appeal, even when your disagreement is completely legitimate. Here are 10 avoidable mistakes, starting with the ones that are hardest to fix. Mistake 1. Filing a new application instead of requesting review. An appeal and a new application do two different things. An appeal asks Social Security to review the decision you already have. The agency's own instructions to its field staff say an appeal allows complete review of the basis and rationale for that determination, whether or not you bring new evidence, and it keeps review of your original claim or issue active. A new application starts a separate claim from a new date. Those instructions also tell employees to explain something specific. If a new application is filed with no new facts or evidence, it may be denied on the basis of res judicata, meaning the same question was already decided, and that this happens most often in disability cases where someone reapplies instead of appealing. Even if the new application is allowed, benefits may be lost. How much is lost depends on the program, and this is where you have to be careful. For SSI, the risk comes from retroactivity. SSI generally cannot pay for months before your protected filing or application date, so a later application date can quietly erase months of payments that an appeal would have protected. For Social Security disability under Title II, the rules work differently. Social Security's procedures state that you generally cannot have two disability claims pending for the same title and benefit type. If a prior disability claim is already in administrative review, the field office is instructed not to accept a new application and to explain that you must choose, continue the appeal, or ask in writing to withdraw the appeal and then file new. Staff are told not to tell you which choice to make. So the right move depends on your program, what stage your claim is at, whether you have genuinely new evidence, and what your notice actually says. What you should not do is treat reapplying as the easier version of appealing. Mistake 2. Counting the 60 days from the day you opened the envelope. The count doesn't start on the date printed on the notice, and it doesn't start on the day you found the letter in a stack of mail. Social Security assumes you received the notice 5 days after the date on the notice, unless you can show you didn't receive it within those 5 days. The 60 days then begin the day after that presumed receipt date. You'll sometimes hear this described as 60 days plus 5 mail days. That's a simpler way of saying a 60-day period that starts after presumed receipt, not an automatic 65-day deadline in every case. Here's a hypothetical example. Say a notice is dated March 5, 2026. Receipt is assumed on March 10th. The count begins March 11th, and the 60th day falls on Saturday, May 9th, 2026. When the period ends on a Saturday, a Sunday, or a legal holiday, it extends to the next full workday. So the request would be due Monday, May 11th, 2026. If the letter actually reached you later than 5 days after its date, you may be able to show that later receipt date, which moves the whole calculation. And if the instructions or dates printed on your own notice differ from this general framework, follow your notice. Mistake 3. Assuming that mailing it on the last day protects you. For appeals, there is no protective filing date. Social Security's guidance is direct. The agency has to actually receive the written request within the time limit. Putting an envelope in a mailbox on day 60 is not the same as making sure the request arrived. The request also doesn't have to be on a special form. A written statement clearly saying you disagree and want an appeal can serve as the request. But filing online through the appeal pages on SSA.gov or delivering it to an office removes the uncertainty about arrival. If the deadline has already passed, that isn't automatically the end. The time limit can be extended for a valid reason, and the request must be in writing explaining why you were late. The listed examples include serious illness that prevented you from contacting the agency, a death or serious illness in your immediate family, important records destroyed or damaged by fire or other accident, not receiving the notice at all, for example because the address was wrong or you had moved, and being given confusing, incorrect, or incomplete information by an agency employee about when and how to appeal. Physical, mental, educational, and language limitations are also considered. That's a real provision, not a courtesy, but you have to ask and explain. Mistake 4. Missing the 10-day window that keeps payments coming. The deadline to appeal and the deadline to keep money arriving during the appeal are not the same deadline. If you're receiving disability benefits and Social Security decides your medical condition has improved so you no longer qualify, a medical cessation decision, the regulation requires a written request for continued benefits no later than 10 days after you receive that notice for payments to continue while the appeal is pending. Social Security's publication states the same thing. For a medical cessation, the reconsideration request uses Form SSA 789, which is a download rather than an online filing. For SSI non-medical determinations, the two sources read differently, so treat 10 days as your working deadline. The publication says that if you're receiving SSI and file an appeal on a non-medical determination within 60 days after receiving the letter, your payments will continue at the same amount until a decision is made. But the regulation sets a 10-day standard for preserving or reinstating payment at the previously established level, and Social Security's current SSI appeals page explains it this way. Request reconsideration in writing within 10 days of receiving the notice, and the payment continues. Request it more than 10 days later, but within 60 days, and your payment may decrease temporarily before it restarts once the appeal is received and entered. Late requests can be considered for a valid reason. So if continued payments matter to you, file the appeal and choose to keep receiving payments within 10 days. Follow the exact instructions and dates in your own notice, and if 10 days have already gone by, contact Social Security right away rather than assuming the option is gone. One trade-off to understand before electing continuation: if the final decision goes against you, you may have to pay back money you weren't eligible to receive. The medical cessation regulation allows waiver of recovery to be considered as long as the appeal was made in good faith. There's also a form to decline SSI payment continuation if you'd rather avoid that exposure. Mistake 5. Confusing an overpayment appeal, a waiver, and a repayment rate request. An overpayment letter can trigger 3 different requests, and they answer 3 different questions. If you don't believe you were overpaid or you think the amount is wrong, that's an appeal. Form SSA 561, Request for Reconsideration. If you accept the overpayment, but you're saying the error wasn't your fault and repaying would be unfair or unaffordable, that's a waiver. Form SSA 632BK, Request for Waiver of Overpayment Recovery. If you owe it, but the monthly withholding is too high, that's Form SSA 634, a request to change the recovery rate. Disagreeing with the number and asking to be forgiven are not the same argument, and the waiver form will not get the amount recalculated. Timing is built into this one. Social Security says it will wait at least 30 days after sending the overpayment notice before starting collection. And if you request a waiver or appeal within 30 days, collection won't start until your request is decided. If nothing is filed, the agency states it will automatically withhold 50% of a Social Security benefit or 10% of an SSI payment each month until the overpayment is repaid. Mistake 6. Filing a valid appeal without identifying what you're disputing. A basic appeal request can be valid without much detail. A writing that clearly expresses disagreement can be accepted, and a special form isn't always required. Leaving the explanation too brief doesn't necessarily invalidate anything. But a valid appeal and a well-developed appeal are different things. Reconsideration is a complete review by someone who took no part in the first decision, looking at the evidence already used, plus anything new that you or the agency add. If nothing new arrives and nothing identifies the disputed issue, that second reviewer is largely looking at the same file that produced the denial. For a medical disability appeal, Social Security asks for Form SSA 3441, the Disability Report, Appeal, along with Form SSA 827, the authorization that lets the agency request your records. Those two help the agency develop updated evidence. They don't guarantee that every relevant record will arrive without follow-up. So it's worth confirming that your newer treatment sources, hospital stays, and test results actually made it into the file. One thing to know calmly, because Social Security tells its own staff to explain it. When you appeal, the agency can review all issues, including parts that were decided in your favor. That isn't a reason to skip a legitimate appeal. It's a reason to understand your own file before you file. Mistake 7. Assuming only disability denials can be appealed. Appeal rights attach to non-medical determinations too. Social Security describes appealable initial determinations as its written findings on legal or factual issues, including whether you're eligible, the amount of your payment, and the fact that you were overpaid, the amount, and whether you must repay it. The path just looks different. A non-medical reconsideration is handled by a local office or a payment center, rather than a state disability agency, and the technician handling it may contact you for evidence. If your notice explains how to disagree with it, that's an appealable determination. Mistake 8. Holding your best evidence until the hearing. At the administrative law judge level, in claims based on a disability application, each party must make every effort to get all the evidence to the judge, and must either submit written evidence or inform the agency about it no later than 5 business days before the scheduled hearing. If you don't, the judge may decline to consider or obtain it. There are exceptions. They apply if the agency's own action misled you, if a physical, mental, educational, or language limitation prevented earlier submission, or if some other unusual, unexpected, or unavoidable circumstance beyond your control got in the way, including actively and diligently seeking records from a source that arrived less than 5 business days before the hearing. You have to fit an exception, not simply explain that you were busy. The next level is not a second chance at this. The Appeals Council will consider additional evidence only when it is new, material, relates to the period on or before the date of the hearing decision, and there's a realistic chance it would change the outcome. And you must also show good cause for not producing it earlier. Records describing how you're doing after the hearing decision generally don't meet that requirement. Mistake 9. Missing the hearing or letting the agency lose track of you. There are 2 separate ways a hearing request can be dismissed for non-appearance, and it's worth knowing both. In the first, if you were notified before the hearing that your request could be dismissed without further notice if you didn't appear, and neither you nor your representative appears, the judge may dismiss the request when no good cause is found for the failure to appear. In the second, the judge mails a notice asking why you didn't appear, and if you don't give a good reason within 10 days, that can support dismissal. Don't count on receiving that second notice. The first pathway doesn't require it. In either case, the rules require considering physical, mental, educational, or language limitations. This is also why contact information matters so much. Hearing notices, requests for evidence, and any letter asking about a missed hearing go to the address in your file. Social Security says it provides notice of the hearing date, location, and issues at least 75 days beforehand, and that if you can't attend, you should contact the hearing office in writing as soon as possible, no later than 5 days before the hearing date or 30 days after receiving the hearing notice, whichever comes first, and explain why. If you move or a family member takes over your mail, tell Social Security in writing. Mistake 10. Guessing about representation and fees. Two misunderstandings pull in opposite directions here. First, representation is optional. You can file at each administrative level yourself, and Social Security does not charge you a filing fee to request reconsideration, a hearing, or appeals counsel review. If you do want help and don't know where to start, your local office can provide a list of legal referral services and nonprofit organizations, including legal aid groups, that either help free of charge or help you find someone. Second, if you do appoint a representative, that person cannot charge or collect a fee from you unless Social Security authorizes it first. Many charge nothing unless the claim succeeds. You appoint someone in writing, either a signed written statement or Form SSA 1696. Fees are approved through one of two separate processes. Under the fee agreement process, the approved fee generally cannot exceed the lesser of 25% of your past due benefits or a set dollar cap, which is $9,200 for favorable decisions issued on or after November 30th, 2024. That cap belongs to the fee agreement process specifically. The other route, a fee petition, is evaluated differently, so don't assume every arrangement is automatically limited by that figure. Either way, the authorization comes from Social Security, and anyone demanding money up front to represent you before the agency is a reason to stop and ask questions. None of this is legal advice about your particular claim. A qualified representative or a legal aid office can review facts that aren't visible from a general explanation. The 4 deadlines worth writing on the envelope. 10 days, the written request that keeps payments coming, required for benefit continuation after a medical cessation decision, and the working standard for keeping an SSI payment at its previous level during a non-medical appeal. 30 days, request an appeal or a waiver within 30 days of an overpayment notice, and collection doesn't start until your request is decided. 60 days, the general deadline to request the next level of review, counted from presumed receipt, extended to the next workday when it lands on a weekend or holiday. 5 business days before an administrative law judge hearing, the point by which evidence in a disability claim must be submitted or identified. The one thing to do before anything else. Find the date printed on your notice. Add 5 days for presumed receipt. Then count 60 days starting the day after that. Now read the notice itself and see whether it gives you a shorter instruction, a 10-day payment continuation election, or a 30-day overpayment response, because your notice controls what you do next. And if you actually received it later than 5 days after its date, say so in writing when you file. Tell me in the comments which stage you're facing, reconsideration, a hearing, or appeals counsel review, and which deadline on your notice is unclear. Please leave out names, claim numbers, and medical details. The general question is enough for me to address it. And if someone you know just received a denial and is about to start a brand new application instead of appealing, send them this first.